I wanted to especially thank Assembly Speaker Sheila Oliver for allowing me to lead this effort in the Assembly, but I also wanted to thank you, Mr. Chair, Chairman Barnes, for posting this monumental civil rights bill for consideration. I think this is the things that we're sent down to do in Trenton with our constituency, to do the tough decisions, to debate matters in a civil way, and not to shy away or hide away by simply pushing the issue off and suggesting maybe this should be better for a ballot measure. We're here to vote on things, and I think that we should not shirk our responsibility. I also want to announce that yesterday, the state Senate in Washington State passed out marriage equality in the full Senate, and they will be the 7th state that will allow or recognize marriage equality. And hopefully that New Jersey will be the 8th. America has always been the celebration of those who struggle for triumph over adversity, and despite the opposition and religious bigotry, it was the right thing to do to correct the ills of discrimination based upon race in this country, and despite the opposition and religious bigotry, we celebrate those who fought for women's suffrage. In fact, our state, despite the opposition, upheld the foundations of liberty when we enacted the law against discrimination, which protects us all against discrimination based on color, creed, sex, national origin, handicap status, and yes, sexual orientation. I hope no one here wants to turn back the clock in our rich history of safeguarding against popular will over the rights of minorities, which has been a bedrock principle of this country since Madison's Federalist Paper number 51. Madison said, "It is of great importance in a republic not only to guard the society against the oppression of its rulers, but to guard one part of the society against the injustice of the majority. If a majority be united by a common interest, the rights of the minority will be insecure." But most importantly, Madison said, in a free government, the security for civil rights must be the same as that for religious rights. I do want to speak to the opposition that says this should simply be a ballot measure. The fact that this audience is filled, the fact that there's been much acrimony, the fact that there's been a lot of name-calling in the last week, imagine what will happen during a ballot question of this type. There'll be more divisiveness in this state, there'll be more acrimony, and it will be a race to who can shout the loudest. And then you also have to ask the person who said that, well, maybe the timing wasn't right during ending the segregation laws in the South. The real question is, when would the timing ever have been right? Today? Next week? I'm sure you would all agree that there are certain segments of the South who still would have voted to uphold the segregation laws. Despite this, you will hear opposition today, but it's nothing more than the repeat of arguments used in the past, particularly with ending the ban on interracial marriages, such as that it would degrade moral development, that it will destroy the institution of marriage, that it will be a slippery slope leading to marrying one's dog, despite the fact paws can't sign legal documents. A1, and our counterpart by Senator Loretta Weinberg, merely upholds the principles established by the U.S. Supreme Court in the Virginia versus Loving decision, which declared the freedom to marry belongs to all Americans, that marriage is one of our vital personal rights, and the right to marry is essential in the orderly pursuit of happiness by a free people. In fact, A1 and S1 does not create special rights, but enacts the safeguards and a recognition found in the Loving decision that everyone has been endowed with certain unalienable rights, and among those are life, liberty, and the pursuit of happiness. That's why New Jersey has chosen to include those words in our state constitution. We have a firm recognition of fairness and equality. That is why A1 and S1 are so important. The creations of civil unions just a short time ago has produced a separate but equal system. And as we know from our history classes, separate but equal is unconstitutional, and as such is inherently unequal. Today, marriage gives individuals countless legal rights, including the priority for inheritance rights, the right to make medical decisions on a spouse's behalf, to get health care coverage through work or file joint tax returns. Only some of these are protected under our civil union laws, so then you have to ask ourselves, why does there need to be this distinction? Why does a gay couple who were legally married in another state, such as Iowa, New Hampshire, Massachusetts, or New York, can be duly married, yet when they cross the border, they become civil unionized? Yet the darling of our social conservatives in this audience, Newt Gingrich, does not have to go through the same hoops. Additionally, many same-sex couples have children, either biologically or through adoption, and denying their parents' right to marry is denying them an opportunity to strengthen their family structure through civil marriage. A1 and S1 seek to rectify these injustices felt by many in our working, taxpayer New Jerseyans, an injustice that the New Jersey Supreme Court ruled back in 2006, and an injustice that the majority of our New Jersey residents agree. And as long as the state is in the marriage business, it should be done on an equitable basis. Fact remains, marriage in this country is a secular right that is afforded to persons who abide by the state laws when they take a blood test and then venture to City Hall to acquire a marriage license. Whether a couple gets married by a person of faith, a mayor, a judge, they must first meet the qualifications set forth by the state to receive a state of New Jersey marriage license. Notwithstanding, to allay the fears of the religious community, A1 and S1 simply reaffirms that no religious or religion institution would be required to solemnize any marriage in conflict with its doctrine or beliefs. It simply provides that any governmentally performed marriage would be a civil marriage and would be open to two consenting adults, whether they be same-sex or heterosexual. Likewise, it would convert all civil unions into civil marriages. I had a discussion before with Assemblywoman Schepisi about her fears that we would force religious institutions to provide their church hall or their other properties to same-sex couples. I looked it up in the law and the bill, and in Section B of 5, no religious society, institution, or organization in the state serving a particular faith or domination shall be compelled to provide space, services, advantages, goods, or privileges relating to the solemnization, celebration, or promotion of marriage if such solemnization, celebration, or promotion of marriage is in violation of the beliefs of such religious society, institution, or organization. So therefore, we reaffirm in this bill that a religious society do not have to offer its church hall or other property when it relates to a same-sex marriage. Finally, Mr. Chair, make no mistake, this is very much one of those struggles for triumph over adversity. We have an opportunity to correct the last vestiges of discrimination in our state against same-sex couples, and especially in light of the opposition who want to divide this country. I especially want to commend the young persons in this audience who know better and ask why not rather than why. They understand the struggle. They understand that the freedom to marry belongs to all Americans, regardless of race, creed, or sexual orientation. We adults should listen and enact this groundbreaking legislation. Thank you.